In today's video, we're going to talk about what happens in court for a petty theft or grand theft case in the state of Florida. My name is Adam Rossen, founder and CEO of the Rossen Law Firm. We're a criminal and white-collar defense firm in South Florida, and we help good people when bad things happen. And in this video, you're going to learn everything you need to know about the court process when you get arrested or charged with a petty theft or grand theft in Florida. All right, so let's get right to it. What happens in court for a petty theft or grand theft case in the state of Florida? Well, really, it's the normal process for any type of misdemeanor or felony in Florida. And what that means is once you get out of jail, your first real court date is going to be your arraignment. And what you do at the arraignment is you're going to plead guilty or not guilty after the formal charges are read to you. Well, if you plead guilty, the case is over and you've been punished. So we don't recommend doing that, especially if you hire an attorney. The lawyers usually always plea our clients not guilty because then the case would be over and we haven't really, had an opportunity to do the work yet. So, but that's what you do at the arraignment. You plead guilty or not guilty. The charges are read to you and the maximum penalties will be told to you. What we do is we usually will waive the arraignment and we'll file what's called a written plea of not guilty. And that's just a normal pleading that we do that says, hey, judge, prosecutor, we've already pled our client not guilty. We want to waive and cancel this arraignment because we've told him what the charges are and it's just not necessary. And the rules allow us to do that. So that's a common practice of us because we don't want our clients to take time off of work to go to court for something so minor as just, yes, judge, not guilty, we'll be fighting the charges, thank you, pay for parking and stress out about all those things. So we don't do that. Usually your second court date will be some kind of pre-trial conference. Sometimes it's called a case disposition, could be called a sounding or a status conference or even a calendar call. And you're going to have a few of these type of cases. And generally speaking, the client's appearance is mandatory unless the attorneys waive it in writing under the rules of procedure. We waive all of our clients' appearances in writing under the rules of procedure, again, for client convenience. If our clients want to come, they can always come. However, we've really found that our clients want to work. They want to, go back to their daily life and not have to show up maybe once a month for 6 months or 12 months going to court because quite often they get beaten and broken down by the process. It's kind of scary, so we want to shield them from that. And usually with us, the only time a client will have to show up is either a motion, a trial, or a plea. And that's it. So most of our cases are, maybe one time. We even have a lot of clients that never show up at all. We can waive the client's presence on all cases from, shoplifting all the way to murder. So, if we can do it on a murder case, we can definitely do it on, a petty theft or a grand theft case. And then what we'll do is we'll discuss about one of the next steps is, do we waive speedy trial or not? And long story short, the prosecutors have to bring you to trial within a certain number of days after your arrest. For misdemeanors, it's 90. For felonies, it's 175, so just shy of 6 months. And for some cases, we're going to aggressively and strategically push those cases forward if, within the speedy trial time frame, because maybe the prosecutors might not have their ducks in a row, they might not be ready, they might not have all of their evidence. But in most of our cases, we're going to want to waive speedy trial. And usually the discovery process will take multiple statuses or calendar calls for us to really go through, especially if we're going to take depositions. Now, in the state of Florida, we're granted some pretty heavy leeway on taking depositions in felony cases. And on misdemeanor cases, we have to get judicial approval, but some certain cases, certain situations, we are allowed to get depositions. And most states and even the federal system, are very restrictive and don't allow depositions. So for us, we have this advantage in the state of Florida because depositions are some of our biggest tools and, just most valuable tools in order to get great results for our clients. And a deposition is basically us subpoenaing a police officer, a witness, really anybody involved in the case to come to our office, and we're going to grill them on questions. Some questions that we know, some things that we don't know. And we've had many cases that we thought were going to be very difficult, or cases that we thought, we might not win. We probably won't win. And we take the deposition, we keep our poker face on during this deposition, and we realize real quickly, hey, we just won this case because of the statement that we got right here in this deposition today, right? It means we're going to win this case a few months down the road. So that's our biggest tool. And from there, we're constantly negotiating throughout the case, but I firmly believe the more work that we do usually leads to better results and increases our negotiating power. So of course we're negotiating through, but if there's things that, the case just isn't, we're not getting the exact result that we want right away, or going through the discovery or the deposition process, well, if any motions come up, basically a motion to suppress evidence for, it could be a violation of usually your 4th, 5th, or 6th Amendment constitutional rights. It could be a Miranda rights violation, an improper confession that they got. So it could be anything involving the 4th, 5th, or 6th Amendment. And what we always say is great things happen when you file motions to suppress. I believe my firm files more motions to suppress than any other criminal defense law firm in South Florida. And we're very passionate about filing these motions because what it does is it puts the prosecutor on the defensive. Right? We go on criminal offense, so to speak. The prosecutors have to then defend against our allegations of police misconduct. And when we're not saying that the cops, and usually in these type of cases, beat somebody up, most people don't even know when their 4th, 5th, or 6th constitutional rights are violated. And so by us making these allegations, the prosecutors have to defend it. It's creating a ton more work, and then they're going to risk losing the case because of it. So great things happen when you file motions. A lot of times then we can get felonies reduced to misdemeanors, misdemeanors dismissed, or felonies dismissed completely. And if not, if it doesn't lead to another negotiation, then we go forward with the motion. And if we win the motion, again, the case might completely be dismissed or at least dismantled by the judge. So those are the steps of, really the major steps of a case. And then, of course, the last step is, well, what do? Do we accept some type of plea, negotiated resolution, or do we go to trial, right? And that's a whole discussion that we have. We never rush clients. You as a client should never, ever be rushed to make that decision. You should have plenty of time. You should know all of the pros and cons of each decision, and not just how it's going to affect you today, but how that decision is going to affect you a year or two from now, and also 10 or 20 years from now when we're talking about careers, not just a job, but a career. We're talking about family life, background checks, where you could be living or not, especially with cases such as fraud, right? What type of employment that might exclude you from. Also, well, what does that mean if you get arrested in the future now that, maybe you've pled to a case? So, when we're talking about possible future sentencing enhancements. So all of those things are very important. And that's really what we consider kind of the last step of a case is we decide, well, do we plea or do we go to trial, right? And hopefully that's given you folks a great understanding of the court process if you're ever investigated or charged with a petty theft or a grand theft case. We love talking about this stuff to people, so hopefully you'll watch us on the next videos in the series that we do. Watch us for everything, and if you ever have any questions, you can give us a call. I'd be more than happy to take great care of you.